Question number 9, Keith Locke.
Thank you, Mr Speaker. My question is to the Minister of Police and asks, in how many trials completed this year have police submitted covert video footage obtained on private property, if any?
The Honourable Chris Finlayson.
On behalf of the Minister of Police, there's a preliminary point I want to make. I note the question refers to evidence submitted, and that will include evidence ruled admissible and also evidence tendered but ruled inadmissible, for example, because of an objection under Section 30 of the Evidence Act. I'm advised the New Zealand Police don't have that information readily available. There are approximately 2,000 indictable criminal cases heard in the district and high courts each year and thousands of summary prosecutions. To provide that answer would require analysis of each of the cases. That's a substantial piece of work and outside the scope of parliamentary question time.
Keith Locke.
Does the Minister agree with the Attorney-General, who said in response to an earlier question today that before the Supreme Court ruling of 2 September on the unlawfulness of the police use of covert video surveillance, that there was, quote, no appreciation of the issue of lawfulness having been raised, end quote?
The Honourable Chris Finlayson.
On behalf of the Minister of Police, yes, although if he was to be exact, the Attorney-General could possibly also have referred to comments made in the Law Commission report, but instead he was focusing mainly on the 15 years of Court of Appeal jurisprudence upholding this activity.
Keith Locke.
Is the Minister saying that she received no advice from police that there had been a High Court ruling on 7th of October 2009 relating to the Operation 8 case that covert video surveillance was unlawful?
The Honourable Chris Finlayson.
On behalf of the Minister of Police, yes, she would have received that report. She would also have received a report that the High Court allowed that evidence in under Section 30 of the Evidence Act, and she would also have received a report of the decision in the Court of Appeal which upheld the lawfulness.
Keith Locke.
Thank you, Mr Speaker. To the Minister, if she did receive advice that there was a question, a determination of the illegality of covert video surveillance evidence, even if it was allowed on this particular case, what did she do to ensure that the police were not acting illegally in the future by engaging in covert video surveillance?
The Honourable Chris Finlayson.
On behalf of the Minister of Police, she would have been relying at all times on the advice of the Crown Law Office, which has had the carriage of this criminal legislation on behalf of the government, and she would also have known that the case was going through other levels of the court system, first the Court of Appeal and subsequently the Supreme Court.
Keith Locke.
A supplementary. Does the Minister agree that because the police continue to use covert video surveillance, that they were doing so essentially flying in the face of court rulings? And does she agree with the Chief Justice's comment in her Operation Case ruling on 2 September that there had been, quote, deliberate unlawfulness, end quote, by the police in conducting filming, and that this, quote, is destructive of an effective system of justice, end quote?
The Honourable Chris Finlayson.
On behalf of the Minister of Police, I'm not going to answer that question because it seeks a legal interpretation, and I would think it would be very unwise in this place to start commenting on judgments, be it of the Chief Justice, Justice Blanchard or anyone else.
Question number 10, Summa